Ready.
All please rise. Court is in session. Honorable Michael C. Hayden presiding.
Please be seated. You may introduce the case, counsel.
Thank you. Good morning, Your Honor. This is 12-1-0162-6 State v. Martin David Pietz, Jr. Kristen Richardson and Carla Carlstrom here for the state. The defendant is present with his lawyers, David Allen and Cooper Offenbecker. Mr. Pietz was found guilty on October 14th of this year of murder in the second degree by a jury. The range for this crime under the SRA is 123 to 220 months, given that he has no felony criminal history. The state's recommendation is for 220 months, restitution, court cost, the victim penalty assessment, the DNA collection fee. There is no recoupment in this case. And I actually made an error in my brief, Your Honor. The community custody term should be 24 to 36 months as opposed to 36 months, because this crime happened before 2009. And we're asking for the mandatory consequences and no contact. Your Honor, the state's recommendation to go to the top of the range, I won't go through my brief again, but I want to reiterate that there are a couple of reasons why we think legally it's justified in this case. First is that the defendant was married to Nicole Pietz. That is the basis of a trust relationship, and in her case it was extraordinary trust in him. The trust that she had for him was that he would not violate the sanctity of their home and attack her when she was vulnerable, naked, prepared for bed. We will never know exactly what happened. The fact that she had her night guard in, I think, speaks volumes about whether she was engaging with him at the time that he attacked her, but in terms of the proof, we were left with what we were left with, and that's why this was charged as murder too in the course of an assault and with intent. The second reason is that the foreseeability of the impact on her family and friends, which are numerous, and I know the court has had a chance to read all the letters sent in by her family and friends.
Has the defense had an opportunity to see all this?
Yes, we have, Your Honor.
Several of those mentioned the fact that at Nicole's funeral it was so overflowing that they had to spread out into chambers outside the sanctuary. The foreseeability of this was magnified because the defendant affirmatively represented that his belief was that Nicole had relapsed, and when in fact he knew that he had put her body in bushes and he was sitting there ready to decompose. The impact on the family and the friends has extended for another 6 years until this case was ready to file. The defendant has been free for that period of time. The state believes that 18 years is an incredibly low amount for a murder in the second degree, but it's what we're left with based on the legislative standard range, and so we're recommending the top end of that. And Ms. Carlstrom has a couple of people that would like to speak to you.
Well, I understand more than a couple.
We do, Your Honor. We have 7. Most of them will be under 2 minutes, and we'll finish with Gail Schneider. I would first ask Ms. Tanya Zerker to come up to the front, please.
Now, as to each one who comes forward, please state your name and your relationship to the case. I know many of you have already testified, and accordingly, it's in the record already, but for purposes of the record, at this point in the proceeding, it's important you say who you are and how you're related to Nicole or to Mr. Pietz.
Good morning, Your Honor. I'm Tanya Zerker, Nikki's sister. Well, I've had 7 years to prepare to what I want to say. The most that he's taken away from me, I will never get to be an aunt. Growing up with her, I won't be able to have her. He took her from me, and taking a life is worth way more than 18 years, so I strongly hope that you give him the maximum.
Good morning.
Good morning.
And Would you state your name, please?
My name is Pamela Schaefer.
Thank you.
I was Nikki's mentor. I loved her a lot. She was a beautiful, kind, compassionate, lovely, wonderful woman who had never hurt a single fly. And she was taken from all of us abruptly. And Dave, I don't understand why you did that. Don't understand why you even thought that that was an option.
Thank you.
Good morning, Your Honor. My name is David Tilzer. I was a friend of Nikki's for approximately 5 years prior to her death. For the last several years, myself, her friends, her family have suffered every day, wondering when justice was going to be served. I was on occasion with Nikki and David and seeing the discare of him and the trust and love she had for him. Nikki was clean and sober. I seen her the week before this all happened at a meeting. She was twinkling in her love for her husband, and he ruined that. He took her away from us. He took her away from her family.
Your Honor, my name is Barbara Arianes, and I was a very good friend of Nicole's. She was my sponsor in AA, and I'm proud to say that. Her life, I believe, the greatest love there ever is between a mother and her child. And Dave took that away from her mother. It just crushed her. It crushed the whole family. It crushed everybody, all of her friends. She touched so many lives. And step by step, this person took everything away from her. She had no future anymore. She couldn't have any kids anymore. She succeeded in life, but can't go any farther because he took her away. He did not have to do that. It was for his purpose and his purpose only. It was all about him, and that's what he thought. But please, give him, I know 20 years isn't very much. If I were sitting up there, I'd give him 35. I'm sorry. But he deserves more. He really, really does. And she is still with us today. She's watching down on us. Thank you.
Good morning, Your Honor. I'm Rod Schneider. I'm Gail's husband, and I have had the misfortune of watching this beautiful woman go through 7 years of pure hell. I watched her sob. I watched her walk the floors at night, her tears. But she was Nikki's advocate for 7 years. Every 28th of every month, she called the detectives to find out reached the point, technically, or for whatever reason, that these two ladies and Jake Pavlovich and Mike Mellis were able to put a case together, and after 7 long years of justice, to bring justice. But what David really took away was the rest of Mickey's life. And how many years might that have been? 20, 30? We'll never know. And the suffering of those people back there just multiplies it. So I just urge you, sir, to, whatever the state of Washington will allow, to impose that sentence and take those years away from him. And please don't give him credit for the time that he has been a guest of King County. Give him the most. Thank you, sir.
Good morning, Judge Hayden. My name is Marilyn Murphy, and my interest in the case today about David Pietz is very personal. I've known Nicole since she was 3 years old. Gail was a colleague of mine at Pan American World Airways, and I had the good fortune of living next door to Gail, Tanya, and Nicole in Lake Sammamish for 6 years. When I first moved in, the very first person that I met was Nicole. She swam from her dock over to my dock, came up the dock in a Wonder Woman swimming suit with the stars and the stripe and the big gold belt. From that moment on, I started calling Nicole Wonder Woman, and she became my very special friend. I always loved seeing this fearless little girl who was very confident, very mature, and had a bigger-than-life personality. Nicole and I had a unique friendship. I was 27 and she was 4. She'd always say to me, "You and my mom are friends, but you and I are best friends, right?" And I'd always say, "Right." I lived in a tiny cottage occupied by someone who had no apparent responsibilities. I wasn't married, I didn't have children, and I didn't seem to ever really work very often. So she felt my house was a place to come and just play, and that's what we did. The year Nicole started kindergarten is the one I remember most fondly. She could read and write, she was very, very bright, and within 2 weeks of school she had decided she wanted to become the teacher's pet. I'd been a teacher, so she thought I had some insider information and could help her achieve that goal. It was in very short order that Nicole was indeed the teacher's pet. Her second life goal was fluffy hair, and to that she looked to me for inspiration. In the span of 1 week, she had 3 home permanents by somebody who had never given a home permanent. It shows how fearless this young girl was. When I think back to this special girl, a very accomplished young woman, it saddens me to think of such a loss of an incredible human being. She had unlimited potential. I want to thank you for using your good judgment, your fairness throughout this trial, and today I urge you to deliver justice to Nicole. I'd like you to please sentence David Pietz to the maximum prison term allowable. By so doing, you will ensure that Nicole will forever be my Wonder Woman. Thank you very much for your time, your wise handling of this case, and the sentence that reflects the profound loss of Nicole Zerker Pietz. Thank you.
Good morning, Your Honor. My name is Gail Schneider, and I'm Nicole's mother. When David killed my daughter, he was playing God. The only person that can take a life is God himself. I find it very sad that it's only second-degree murder because a life is a life, and she was deprived of her life. David lied to us throughout the marriage. He was always saying how broke they were. Well, gee, he was fired twice for sexual harassment, so he was out of work a lot. All the business of what Nikki was doing with her pills, I'll stake my life on it, that he was the one that was selling those pills. How else did he get the money?
How else did he get the money to buy this girlfriend a cell phone and take her to nice dinners and lunches? And that was only one. What about all the other girls that he was courting? And how was he paying for this sex club he went to all the time and the ecstasy? It's hard for me to believe that Nicole was blamed for the use of those pills, because the way he could maneuver her, he could have taken those prescriptions and done what he wanted with them. I've let David take my life for the last 7.5 years, but I'm not going to anymore. David, I forgive you. I would not be able to go on. I'm not going to allow myself to let you ruin my life anymore. And for those that thought I was acting childish when I went to his places of work, it was the only way I could talk to him, Your Honor. He would not speak with me. So I had to take rather strange methods to get to see him. And all I wanted to do was look him in the eye and ask him how he could look in the mirror in the morning knowing that he'd killed my precious daughter. How did he look in the mirror in the morning when he shaved? I don't understand. But like I said, David, I forgive you. I hope someday your family can, because you didn't just destroy my family, you destroyed your own family. Thank you, Your Honor.
Does that complete the state's presentation? Counsel?
Yes, Your Honor. We'd like to call 2 people to speak on David's behalf.
And you may.
That's David's father and mother. And they've asked me to make a request to Your Honor that they not be photographed or videotaped.
You know, I'm not sure I can honor that request. This is an open courtroom.
Okay, well,
I mean, I recognize it, and I can understand that they would make that request. But I think our courts have made it very clear that this is an open courtroom. It's open to the public. It's open to the media, and I can't direct them as to who they can film, except a defendant where identity is an issue.
Thank you, Your Honor. I first ask Sandy Pietz to come forward.
Would you come up here, ma'am? You can come around here. He indicated, come forward. He indicated your name, but if you could state it again for the record, please.
My name is Sandy Pietz, and I'm David's mother. By way of introduction, I let you know that I have 39 years in government service. The past 12 years have been as the Pierce County HR Chief Examiner for the Sheriff's Department and Manager of Organizational Development Training until I retired in April.
I'm sorry, the court reporter can't hear you. Could you move this maybe on the other side of that? Could you folks come down a little bit so she could get closer?
Do you want to say it again? The whole thing?
She's HR at the Sheriff's Office, but she's now retired. Did I pick up the gist of it?
Pretty much, yeah. 12 years in Pierce County Human Resources, assigned to the Sheriff's Department as Chief Examiner, and retired in April. David has always been a loving son, and as an adult he has stayed involved with and is very close to members of his immediate family. He has always been outgoing, participating in various sports and student government activities throughout his school years. And he served as a youth leader in his church activities. David has always worked hard and has shown responsibility and a strong work ethic. During this difficult time, David has continually expressed concern for me and other members of his family. I and other family members will continue to support him as always. His aunt and uncle are also here today to show their support for him. I love my son with all my heart.
Next, ask Martin Pietz to step forward.
Yes, sir.
Your Honor, I am Martin Pietz. I'm Dave's father. I'm retired after 32 years of working for the Department of Transportation in Olympia. David had a very normal childhood. He did well in school and had no problems socially or academically. He was a wonderful son. He worked part-time after school, and in the summer he worked hard and was proud of being a good, reliable employee and what he accomplished. He was never in any trouble. In college he did as well, and as his mother mentioned, was involved in an elected official as student government. He has been actively involved with his church, where he has met many friends, and for a time was involved there as a youth leader. As his father, I love and support him, as does his mother, as she mentioned, his 95-year-old grandmother, and his other family members. His entire situation has been absolutely a horrible shock to us in this extremely difficult time. Thank you, Your Honor.
Thank you, sir. Mr. Allen, are you going to address the court on his behalf?
Yes, I will, Your Honor. We filed a defendant's pre-sentence statement. That basically sets forth our position. As the court knows, we're asking for the middle of the standard range for reasons we gave in that memorandum. I really have no more to add than that.
Thank you, sir. Mr. Pietz, this is the moment where you may speak on your behalf. It is referred to as the right of allocution. You're not required to speak, but you certainly may. This is your time to address the court and any of the family present if you wish.
Your Honor, David Pietz and I have discussed this beforehand, and he's not going to make a statement.
Okay, very well. Does that conclude the presentations?
Yes, Your Honor.
Yes, Your Honor.
There's been a lot of reference to the time interval between the death of Nicole and today's date, and references to, I think, upwards of 7 years. I think that we're coming up on the 8th year in January. The sorrow and the anger that I feel I think is palpable in this courtroom. It's still raw after 8 years. And I don't know of any way to adequately address the pain felt by a parent who loses a child, whether that child is an infant, a juvenile, or an adult. I think that we can recognize that in the natural course of things, we expect we parents to pass first in a natural progress, and our children to mourn our passing. It is a disturbance of that natural progression when a child dies so young and the parent has to deal with it. I don't believe that any compassion I can express or any compassion that comes from any of the family and friends can adequately address the loss that a parent feels under these circumstances for the loss of a child. I don't think time heals all wounds. If it did, we might be in a different setting today. To the family and the friends here, I have read your letters. Most of those call out for a harsh punishment by the state. Some are in support of Mr. Pietz. The vast majority, I think, are on the other side, and I think I've shared those letters with the defense. They know what I'm referring to. I wish I could provide closure to the family and friends by what I do this morning, but that's really beyond my power as a judge to do. I can't provide an adequate explanation for why Nicole Pietz is dead. I would suggest that the mother's forgiveness is a step in that direction of closure. Ms. Snyder, I think you recognize that the anger that you carry with you probably eats at you as much as it eats at him, and that going through that period of resolution and forgiveness is probably the first step toward healing. We heard just about a month of evidence concerning the defendant's involvement with other women during his marriage. And I think during the course of defense closing arguments there, I detected perhaps a concession in the defense that he engaged probably in a lot of that, and it made him a poor choice for a husband. It made him certainly on the narcissistic side of the scale of psychology. But while his conduct was admittedly deplorable, his activities with other women was not criminal, and it did not necessarily mean that he murdered his wife. It was admitted for other purposes. I do not know what evidence was persuasive to the jury and what evidence compelled the jury to its verdict. I do know what evidence was persuasive to me and what evidence I think is important in considering an appropriate sentence in this case. We all heard ample testimony concerning Nicole's medical history, her struggle with prescription drugs, her addiction to prescription drugs, and her visits to AA and her efforts to recover. No doubt, and I think it's well known that David you were well aware of her struggle. You knew full well when you married her that she had that struggle, and you knew it through the course of the marriage. What I found particularly appalling prior to the date of her death was the testimony that in a nightclub down on Western Avenue, I think, maybe in Belltown, without her knowledge, you placed an illegal substance in her drink. You did it for the purpose of inducing her to perform a public sex act on you. The rest of it that you did with other women is not criminal. Likely what you did to your wife that night was criminal. Giving someone illegal drugs against their consent and knowledge is probably an assault. Had you done it to a woman not your wife, it would probably have been rape in the second degree. The state didn't charge those offenses. At the very least, I regard it an act of domestic violence against your spouse. I think it showed, given her addiction, your utter disregard for her safety and her well-being. You don't spike an addict's drink with drugs if you care about them. You don't know what spiral you'll put them into. You did it for your own personal sexual satisfaction, and I found that, when I heard the testimony, absolutely abhorrent and criminal. I don't know what happened on January 27th, 2006, when you got home. There was no evidence to suggest what happened other than you went to the grocery store, you picked up some items, and you went home. You gave various explanations, somewhat contradictory explanations. This is exactly what happened. And we don't know what confrontation led to Nicole's death. I think it's a fair inference that there was a confrontation over something, whether it was over finances, over your history with other women, over her discovery, that I do not know. What we do know from the evidence is that you killed your wife at very close range, within an arm's length. The inference is that she was able to look into your eyes when you did it. You were able to look into her face when you did it. And that the resulting death took a course of several minutes rather than a few seconds. I don't know what was going through her head as she looked into the face of the man she thought she loved as he took her life away. I cannot conceive of her thoughts at that moment. I don't know. We know that you had time to think about it. I think the state, during its closing arguments, looked up at the clock and said, let's tick off 15 seconds, as if to show how slowly time can pass. When the testimony was, the event would have taken a matter of minutes. I think it was 8 minutes. I don't know, and I don't think they knew precisely how long it would have taken. for her first to become unconscious and then to die? I don't know. We do know that after the death, you carefully planned the effort to cover up the complicity in the murder. That much was clear. I think that much was clear to the jury. The state has presented cases that suggest that that is can be an aggravating factor to a sentence. They are not asking for an exceptional sentence up based on that factor, and in fact they can't. They have no power in this case to ask for an exceptional sentence, but they provide case law that says it is the basis for a judge to, I think, to be concerned. You misled the family. You added to the tragedy that they were already feeling. And ultimately it fell apart. And I suspect that you found out that you weren't quite as smart as you thought you were. And we're standing here today. The state did not claim nor charge you with planning Nicole's murder before you got home that evening. They did not charge you with having the intent to kill her before you got home that evening. But the evidence is pretty clear that as you committed the act, that was her final act. You had plenty of time to think of it as you looked into your wife's eyes or her face. And it was a matter of minutes that you could sit there and think about your disregard for her, your disdain for her, and your self-love and your loathing of her. I think all these factors lead me to suggest this was not a standard, if there is such a thing, murder in the second degree. All murders are horrific. Most murders in the second degree that I've tried, and I've unfortunately tried a lot of murders in my career, more than I want to think about, more than I want to count. Most murders in the second degree are momentary acts of anger or aggression. Pulling a trigger, a blow to the head, other things where the impulses get out of the way, get in the way, that blow is struck and somebody dies. This is the first case I've tried where it was so close, personal, and lasted so long as a murder in the second degree. And in my judgment, that places it within the category of those offenses at the most aggravated end of the offense. Those are the factors I've considered. Accordingly, the sentence will be at the high end of the standard range of 220 months. And I think there was a suggestion from others, certainly in the correspondence and in the statements here, that the court and the state should seek something in excess of that. The response to that is, you can't. I have no authority to impose any more than 220 months. The state has no authority to ask for any more than 220 months. There will be 24 to 36 months of community custody, victim penalty assessment, DNA, and a lifetime bar prohibition to have any contact with the Pietz family.
Sorry, Your Honor.
Yes, sir.
The Schneider family.
I'm sorry. I apologize. The Snyder family. You're absolutely right. With Nicole's family.
Yes, sir.
I apologize, counsel, I misspoke. Anything else? Can you bear the judgment and sentence?
Your Honor, just that it reflect
Yes,
credit
sir.
for time served in the King County Jail.
There was certainly a suggestion from someone as they spoke that I should not give credit for time served in the King County Jail. I would suggest to that request that is also outside my power. Every defendant is entitled to credit served in the county jail or at the Department of Corrections on a charged case. The time will be calculated by the jail and will be credited by the Department of Corrections.
Your Honor, one other matter.
Yes, sir.
In one of the sections here, there's a no-contact order, and it includes the Schneider family and Ms. Zurcher as part of the Schneider family. And we have no objection to that.
But you said the Snyder family and the...
Ms. Zurcher, who's the sister. We
Oh,
obviously have no objection to
I
that.
understand, okay.
But the state has included several other people who were witnesses here. They weren't eyewitnesses, If anything, they were...
And they will not be included if they have a concern later about some type of behavior on his part. They would have to seek their own separate orders.
Thank you, Your Honor. May I strike their name from the...
You may, counsel.
Order.
Your Honor, we had also handed forward the 3-5 findings that both parties
I
signed.
saw
Does the
that. Did
court
you sign
have
off on
those?
this, Mr. Allen?
We did, Your Honor.
I mean, there were fairly non-controversial 3-5 here.
Yeah, if we didn't sign off on them, we gave the state permission.
There's a signature on it.
Thank you.
And just for the record, the state also prepared proposed findings for the 404B evidence, and we could not reach agreement with the defense.
I suspect, do you need to have that heard today, or you want to do that post?
No, it doesn't need to be heard. My understanding is the defense will not be agreeing to any 404B findings.
Well, I anticipated they wouldn't. Counsel, do you want to set that for further hearing?
No, Your Honor. I think we've reached an impasse here, and it was our position that findings aren't necessary because they're on the record Your Honor has made them. So the record speaks for itself. And unlike a 3-5 where it requires...
I wish records did speak for themselves. Sometimes they tend not to and get interpreted many different ways. But, yeah, I know.
But I think there were so many rulings in this case, it's going to be impossible to try to...
All right, thank you. So you'd say let the record remain intact and don't compound it with any additional findings on the 404B?
That's our position, Your Honor.
I will consider that. You may pass them up, and I'll decide whether I need to sign them.
And, Your Honor, it goes a little farther than that, because the court's required in a 3-5 hearing. There's no requirement at all in a 404B situation. And also, it's unlike a 3-5 where the court's actually seeing witnesses and taking evidence.
Counsel, I understand.
Thank you, Your Honor. Your Honor, I've signed off on this. Usually there's a page for the defendant to sign. I don't see it here, but...
Is this the last page of the agenda?
Yeah.
Well, there are some items he will have to sign.
We do have that.
I mean, one of the items he will have to sign is a permanent prohibition on the right to bear a firearm.
And
Also the right to vote.
Mr. Pietz has signed off on the fingerprint form.
He's also signed off on the loss of firearm right and right to vote and appellate rights, Your Honor.
Mr. Pietz, I don't infer that you have been a person that has had firearms over the years. I don't know. But you should understand that this prohibition is not only against firearms that you own, it also includes a firearm over which you may have gained access or constructive possession. Meaning it could be somebody else's firearm, somebody sitting next to you, they put it under your chair, and for purposes of this firearms prohibition, it could be construed to be in your possession. And it would be another felony.
Your Honor, I think we neglected to bring up the proposed 404B, so we are happy to email them to the court. Counsel has them, and then if the court wishes to have us set a hearing, we could do so.
Gary.
Mr. Pietz, you will get a pleading here in a moment. It's notice of rights of appeal. You have 30 days from today's date to file your notice of appeal. I anticipate that one will be filed, and your counsel is well aware of the time deadline, but it's my responsibility to also tell you about it on the record.
Also, or no? Oh, put all your fingers there.
That's not going to do it. It's going to need to be doing darker here. The clerk will send it back.
I want to read on David. Why don't you have them do it the way they want to? Do you guys? We don't know how to do this, so you tell
He
us
did
what
it
you
just
want.
right. He just needs to push harder
Okay, do all.
because they're going to
No
be
thumb,
scanned.
4 fingers down to the knuckles.
Do it flat, yeah.
And he'll cross out the other ones.
Yeah.
That's
There you
fine.
go. Can I hand you a copy of the notice of ineligibility to possess a firearm and loss of right to vote to counsel?
We acknowledge receipt of those.
What's your copy?
Is it anticipated there will be a restitution hearing?
I think there will be, Your Honor, yes.
Would he waive his presence at a future restitution hearing?
Excuse me. Would you waive your presence at a future restitution? Mr. Pietz would waive his presence.
And then I did not check the date to be set box because I wasn't sure how the court,
In
so.
a future hearing, and you can set that once you get, like, the information you have, 180 days.
Yes.
You want to scratch? You going to scratch out some of those? Why don't you check the adequacy of it? Look okay? Well, you're the expert on fingerprints. It's okay with the clerk of the court. I'll accept it. It's acceptable? Anything else, counsel?
No, Your Honor.
No, Your Honor.
This concludes this matter. The court is now in recess.
Please rise. We ask everybody to here, seated, while we're and when you're free from that, you'll build every day.
How many copies of James?
One is fine. We'll make copies back at the office. She was quite the lady.
Well, they're holding our testimony after the first year.
Oh, good, so you get a break, thank goodness.
Break, and then we have to get all the probably sometime.
You'll be able to have her